this matter, and also for posterity, because traditions and precedent are important, I rise under Article 75 on the conduct of state officers, Mr. Speaker, and I beg to read, and I shall be very quick. A state officer shall behave, whether in public, an official in private life, or in association with other persons, in a manner that avoids any conflict between personal interests and public or official duties, compromising any public or official interest in favor of a personal interest. So, Speaker, I invite you also to look at our standing orders, just in quick succession of standing order number 252 on attendance before the National Assembly and reverse. So, Speaker, Mheshimiwa Silvanus Osoro is a member of Parliament of South Mugirango, where the Deputy Governor is facing impeachment allegations. Number 2 is the Majority Chief Whip in the National Assembly, Mr. Speaker. So my concern, in as much as I'm aware of Article 50, but you must interpret the Constitution, both Article 50 and Article 73, Mr. Speaker. I'm aware Deputy Governor Monda is allowed to have a legal representative of his own choice. Mr. Speaker, is it in order for my brother, Mheshimiwa Silvanus Osoro, the MP of South Mugirango, to appear on behalf of Robert Monda, the Deputy Governor? 1, because he's a state officer, and 2, of conflict of interest, that he might send a mixed signals that he is a chief whip of the majority side in the National Assembly. And number 3, whether, looking at standing order 252, whether the procedure of ensuring him appears before the Senate, not only as an advocate, but also as a member of Parliament. Mr. McHugh, under Article 93, member of Parliament is both a senator and a member of National Assembly. Mr. Speaker, some of us who are learned friends would have wished to appear on behalf of either side. If we allow Honorable Osoro to appear, it means as a member of Parliament, as defined under Article 93 of the Constitution, we can also appear on behalf of either sides that are bringing impeachment motions, Mr. Speaker. And number 2, and finally, it is in the public domain, and this will be my conclusion, that the governor of Kisii, Mheshimiwa Simba Arati, and Honorable Silvanus Osoro have had a public altercation. Mr. Speaker, I beg that we should not use Senate as a playground of local politics of what is happening in Kisii, Mr. Speaker. Could it be Senator Osoro, Honorable Osoro, and Simba Governor Arati extending their playful political ground to the Republic of Senate, Mr. Speaker, where we are here only to listen to charges that have the basis of evidence and can stand the test of legal and constitutional and standing orders, Mr. Speaker. So I beg that you rule that Honorable Osoro should relinquish himself from representing Honorable Monda, go back to his house business in the National Assembly, and serve our party, the UDA and Kenya Kwanza majority national. He is a chief whip. We might lose some of the bills at the National Assembly, while Mheshimiwa Osoro is busy representing for personal, financial, gainful, and propelling his professional at the expense of the position that we gave him in the National Assembly, Mr. Speaker. So I beg your ruling, and Senator Osoro should go back to serve the people of South Mugirango and members of National Assembly, Mr. Speaker, and allow this House to proceed. And I know Senior Counsel Katwa Kigen and the other retinue of colleague Leonard can do their job well, Mr. Speaker. So I request that on PO, let Mheshimiwa Osoro, there is no problem. They can still continue fighting with Governor Arati in funerals in Kisii, but not in this House. I submit, Mr. Speaker, sir.
Now, yes, Senator Boni.
Thank you.
I hope it's a new matter altogether, not related to what has already been raised.
Mr. Speaker,
Is it something new, Senator Boni?
yes,
Proceed.
it is new to the extent that he has raised 4 things upon which you should rule. Mr. Speaker, I'm inviting you again to consider ruling on a 5th thing, namely that whereas this is the Senate, but in this chamber this morning and for the next 2 days, Mr. Speaker, we have converted ourselves into a trial chamber. And therefore, Mr. Speaker, any member of parliament seated in this chamber is seated here as a judge to what's going on. Mr. Speaker, the invitation I'm asking you to make is that if you allow the Honorable Osoro to then sit in this house and do something other than what a member of parliament is supposed to do in a trial chamber, is it not, Mr. Speaker, tantamount to having a sitting of the High Court, for example, where a judge who would have sat on that matter then jumps and becomes an advocate in the same court, Mr. Speaker? And Mr. Speaker, because we are now going to be setting a precedent, we request you to consider this issue long and hard, because we have some very eminent lawyers in the National Assembly and this Parliament who will then start abusing this to the extent that it will be the disadvantage to the impeachment process. I thank you.
Senator Sifuna.
Thank you, Honorable Senator. First of all, I join...
Is it on the issue of...
no, it's a
Senator
separate
Osoro?
issue.
It's on the issue of Honorable Osoro?
I want to go on record, Mr. Speaker, supporting the positions taken by the 2 senators. But I wanted to, with your very great indulgence, Mr. Speaker, because one of the parties has asked us to make a decision on a matter, I was hoping, Mr. Speaker, I could find some clarification on the understanding of the rules of the procedure for this particular process. Mr. Speaker, allow me to find out from the advocate for the deputy governor whether in their understanding there is a distinction between evidence and an allegation. Because my understanding of the standing orders, at least as I have read them, is that for as long as there is evidence supporting an allegation that was present in the county assembly. And I'll give a very specific example. If you're being accused of, say, corruption, is it possible that if there are 10 pieces of evidence and 7 are used in the county assembly, is it possible or is it their position that the remaining 3 pieces of evidence supporting the same allegation that was present in the county assembly cannot be presented before the Senate? That is the question I want them to answer for me as I ponder what to do with their objection. And number 2, whether it is their understanding that a public participation is a evidence collection forum. Because in my view, Mr. Speaker, when you go for public participation, you are presenting the case against the deputy governor as framed in the county assembly for the public to engage with that case. So that if I'm being accused of corruption, and that is what goes to public participation, is it possible that other people, upon hearing those allegations, might also say, I was also a victim? And then what in their understanding are we supposed to do with that material? I thank you, Mr. Speaker.
Counsel.
Thank you, Mr. Speaker, sir, and honorable members. Our emphasis on the Rule 20 is that it prohibits both new evidence and new allegation. Now, on the face of that rule, it's not very clear indeed, and that is an issue I've belabored, whether the intention is that evidence that supports an already existing count is tenable. However, the words used are, assembly is prohibited from introducing new evidence that was not part of the allegations. So that if there is an allegation already in place, and evidence was already adduced to support that allegation, you cannot bring new evidence in addition to what was canvassed at the assembly. That's my understanding. I can see you disagree with me, Honorable Sifuna, but that is my understanding of it, that it is cast in stone what was done at the assembly to the extent of the material in support of those counts is what should be brought here. Because then the inverse argument, honorable members.
Councillor, I think you've made your point.
Yes, and then there was a second limb of what he was asking, what becomes of public participation. Public participation in itself is a wild animal. You wouldn't know what will come from public participation. But it is my position that if in the public participation somebody were to say that indeed I have been a victim of corruption from the same person who is facing an impeachment, that is a standalone case that should go back to the assembly. It cannot be a basis of a case before the Senate, because then you will be placing the subject of the impeachment in a situation where he has no chance of responding to the new allegation brought in through the public participation. So if the evidence, for instance, collected from the public participation were to say I was present when the M-Pesa was being sent to Lucy Wahito, or I was present when Dennis was paying the bribe, then that in a way probably you could almost accommodate. But when he says I also was asked for a bribe, then that's a new case. We should go through the whole process of impeachment, right from the point of the motion to the point of from the point of notice to point of motion, and so on and so forth. That is my answer, Honorable Speaker.
Senator Aroba.
Thank you, Mr. Speaker. I just want to bring to the attention of the House on the issue of expunging certain submissions. Mr. Speaker, I think it is imperative that we understand that the individual who's on trial here is the Deputy Governor, Mr. Speaker. And when I look at some of the submissions and where we are being pulled towards in terms of for instance, the reference on page 56, where we are told that we have to listen to certain issues that have been submitted with regards to the governor's wife, Mr. Speaker. As you have seen, and we have all seen previously, we have really tried as a Senate to stay away from the issue of the office of the First Lady or the First Gentleman, Mr. Speaker. And more often than not, including in these submissions that I have had being discussed in terms of being expunged, more often than not, it is a way of digressing this House from actually focusing on the charges, Mr. Speaker. The charges that are before us are 4. They are of gross violation, abuse of office, gross misconduct, and crimes under the national law. None of these charges, Mr. Speaker, are directing us to the wife of the governor. Mr. Speaker, so as you make that ruling, I implore you, Mr. Speaker, that you understand that this issue of the office of the First Lady and the First Gentleman is often being used to bring non-issues to this House, Mr. Speaker. So I want to point out to both parties that, first of all, the governor's wife is not going to appear before us. So therefore, we should it is not forming part of this impeachment. And so therefore, Mr. Speaker, if you can guide that we do not reduce the House into a House that is going to discuss matters of patriarchy or feminism, or the issue of the first office or not the first office. The person who is here is the Deputy Governor, and we should limit our discussions on whether this particular impeachment has weight to impeach a Deputy Governor, and leave away the issues of or trying to bring about the spouse of the governor or any other person in this impeachment. Thank you, Mr. Speaker.
Senator Ledama.
Thank you, Mr. Speaker. Mr. Speaker, I want to bring to your attention Rule 30.
You have less than 2 minutes.
Okay.
And Rule 23.
Okay. Rule 20. Okay. Thank you, Mr. Speaker. Mr. Speaker, I was trying to make sense of what the two parties, the Assembly and also the Deputy Governor were trying to allege in terms of the introductions of new evidence. Mr. Speaker, Rule 30 of our impeachment rules states as follows, that when a particular question or matter, including but not limited to questions of evidence, materiality, relevant competence, or admissibility of evidence, and any question, consequential or incident thereon, no provision has been made in the standing order or in these rules, the Speaker of the Senate shall rule on the questions on matters, and the ruling of the Speaker shall be final. Mr. Speaker, the reason why I stood up is because of the parity of the evidence. In this case, I've had both parties alleging that there is introduction of new evidence. I'd like to request that you apply Rule 30 so that during our closed session, you can determine that matter, and then we can be able to progress. Thank you, Mr. Speaker.
Now, to make progress, I'd wish to hear from the Deputy Governor's team a response to the preliminary objection by the Senator for Nandi. And also, I'd wish to hear a response from the County Assembly on the preliminary objection by the Senator for Nandi. Proceed. Proceed. I'll come to you. Okay. Honorable Senators, I'm informed that the Senator for Kisii cannot hear me because you're making noise. Kindly be silent. Proceed.
Mr. Speaker, sir, my understanding is that you're inviting me to respond to Honorable Ladema's point in reference to Rule 30. Oh, okay.
For Nandi, who raised the preliminary objection opposing the appearance of Honorable Osoro.
Mr. Speaker, sir, I'll be as brief as this. Our position is that this Honorable Senate and the National Assembly are different functions. Number two, the impeachment jurisdiction that you're exercising today is not a function that is exercised at National Assembly. And for that reason, there is no conflict in Honorable Osoro appearing here, considering that there would be no occasion and no situation where we would have to influence or contribute to the question of whether the impeachment can proceed or not. I would also want to identify myself with the submissions by Honorable Kalwale and say, up to the last minute we were together in the sense that if you are sitting already as judges, then we know that your members have appeared before court and conducted proceedings there. And insofar as therefore you're sitting as a court, then Honorable Osoro, for as long as he's not a member of this Senate, can participate the same way your other members have been able to make contribution in the court pressings. I pray that you allow Dr. Monda to enjoy the services of an advocate of his choice. Thank you, Mr. Speaker, sir.
Mr. Speaker, sir, part of the benefit of attending law school and being a senator as distinguished as they are is that allow me to address the senator for Nandi as my junior learned friend, that he has correctly put it right, that there is no distinction, constitutionally there is no distinction between the National Assembly and the Senate. Pursuant to Article 93, there is established a Parliament of Kenya which shall consist of the National Assembly and the Senate. And as such, my learned friend, Mr. Osoro, with all due respect, cannot then behave like a ping pong. He cannot have his bread and eat it. He must choose whether he wants to be a legislator or he wants to be an advocate. The tragedy of premising a case such as this one on misconception of facts is that Mr. Osoro wants to convert this distinguished assembly to a field day somewhere in Nyarimbari Church. And as such, Mr. Osoro then cannot then continue to appear as an advocate and as a member of parliament. He has to choose which court does he want to wear.
Now, honorable senators, it is now 1:38. We are going to adjourn and resume at 2:30. I'll be delivering my ruling at 2:30 before we proceed with